Now are we live? Huh? Okay. Hi guys. Do let me because it's showing here that I am live. So why is it not going live? Now it's live. Now it's live. Okay. Okay, guys. If you can hear me, just give me a heads up that yes, we are live. Okay, you can hear me, right? Okay. 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 So today we are going to discuss the swift scans of Indian Contract Act. And I am just hoping that your studies are going amazing, amazing, amazing. So, okay. How is your studies going on, guys? At least do let me know how is your studies going on. I hope it's great. Yes. So as you know, in the Swift scans, I have put up all the videos for the rest of the Swift scans also. And if you want me to do a live session for sale of goods at Swift scans also, just give me a thumbs up there that yes, you want a live. In that case, I'll arrange a live one this once this live is over. Just in another 5 minutes, I'll start the live of Sale of Goods Act. If you want me to do it, you can just let me know about that. Okay. So as I said, we are going to discuss the Swift scans of Contract Act here, and the special contracts I've already uploaded. So you can just go and check that. Here we are going to discuss all the rest of the Swift portions of Swift scans of Indian Contract Act, the practical questions, and we are going to try to figure out what provision we will write in that and also the answer for it. Okay. So okay, you need soga. So we'll do one thing. In that case, what I'll do is I will just sorry. What I'll do is I'll just after once this is over, I'll just immediately arrange a link. It will take 5 minutes or 10 minutes to arrange that next link, and I'll do that and I'll share it. Okay. So moving forward, I'll just give me 1 second, guys. I'll just start it. Okay, so let's start and try to figure out the questions or with the answers yourself also while I'm reading the question. Try to figure out the question so that you also have the answers for the questions. Okay. So, and yes, you can keep writing. You should keep writing. Don't sit there listening to me. That becomes a little too boring after a point of time. And also, what you are doing then, other than listening, you're not doing anything. So, I would suggest and recommend that you guys also keep writing your answers. Okay. So Radha invited her 10 close friends to celebrate her 25th birthday on the 1st of Jan. Invited her friends to celebrate her birthday. Okay, so this itself shows that it is what? A social agreement. On 1st Jan 23 at 7:30 p.m. at a well-known hi-fi restaurant at Tonk Road, Jaipur. All invited friends accepted the invitation and promised to attend the said party on request of the friends they agreed, but it is just the social agreement, right? It is just the social agreement. On request of the hotel manager, Radha deposited 5,000 as non-refundable security for the said party. On the scheduled date and time, 3 among 10 invited friends did not turn up for the birthday party and did not convey any prior communication to her. Radha, enraged with the behavior of the 3 friends, wanted to sue them for loss incurred in the said party. Advice as per the provisions would your of the Indian contractor. Can she sue them? No. Why? Because it's just a social agreement. So I have to write, I have to explain about social agreement and I have to write why it is not enforceable by law. I have to basically explain agreement and how agreement is not legally enforceable. What would be your answer? Would your answer differ if the party had been a contributory New Year celebration party? If it was a contributory New Year celebration party, means we all will pool in our money and accordingly we will have a party. So when it is agreed that we all will pool in our money, then in that case, obviously it becomes an, it is not just an agreement, but it is a contract. And in that case, can she sue her friends? Yes, she can sue her friends. The next one, X agrees to pay Y 1 lakh if Y kills Z. To pay Y, so X makes a contract with Y to kill Z. That he says, please kill Z. And if Y kills Z, to pay Y, X borrows money from W. He borrows money from W to pay Y. So, first of all, the contract between X and Y is what? Illegal. And whenever you are making a contract which is collateral to the illegal contract, that contract is what? Void. Who is also aware of the purpose of the loan. Since he is aware, if he was not aware, then it would have been valid. But since he is aware, the contract is what? Void. Y kills Z, but X refuses to pay. X also to repay the loan to W. Explain the validity of the contract of X and Y. X and Y ka contract is what? Illegal. Correct? Between X and W, it is what? Between X and W, it is void. Lovely, lovely. I'm seeing you all are writing, and that's amazing. That will give you next level of confidence if you're writing right answers. No, it will give you next level of confidence. Mr. Joy owns two flats in a building. He wanted to sell flat number 101 to Mr. Roy. Mr. Joy offered to sell his flat number 101 to Mr. Roy, but Mr. Roy thought that Mr. Joy wanted to sell flat number 102 and said yes for the agreement. So he is basically talking about one flat and this guy is talking about another flat. So here there is no what? Consensus ad idem. Correct or not? Consensus ad idem. Can we also say it is a bilateral mistake? It is a bilateral mistake of fact. Correct? The contract is what? The contract is void ab initio. State whether there is any contract in the following cases. I want the answers rolling in. All the answers should keep coming. State whether there is any contract in the following cases. A engages B to do certain work and remuneration to be paid as fixed by C. Valid. Third party can fix remuneration. The whole point is I should get money. You fix, I fix, someone else pays, doesn't matter. A and B promise to pay for the studies of their maid's son. A and B promise to pay for the studies of their maid's son. This is just a social agreement and it is not valid. A takes a seat in a public bus. A takes a seat in a public bus. So when you take a seat in a public bus, it is what? It is a tacit contract. Correct or not? It is a tacit contract. So is it a valid contract? Yes, it is valid. It is tacit. A chartered accountant promises to help his friend to file his return. Okay. Are you helping him to file his return in the form of a CA or as a friend? You are helping him to file his return as a what? As a friend. So since you are helping him as a friend, it is what? It is a social agreement, right? And a social agreement is not valid. So I hope it's clear to all of you. Moving on to the next one. A bought goods from B in 2015, but no payment was made till 2019. He was supposed to pay in 2015. Payment not made for 3 years. It becomes what? It becomes time barred. So this is what? Because it is time barred, it is unenforceable. Correct? G agrees to give tuitions to H, a pre-engineering student from the next month, and H in consideration promises to pay rupees 5,000 per month. Can we say they have not done anything yet? They will perform on a future date. Yes, it is what? Executory or bilateral. The words are used synonymously, executory or bilateral. So with this, we are done with the first chapter. Now moving on to the second chapter, which is offer and acceptance. A sends an offer to B to sell a second-hand car for 1,40,000 with a condition that if B does not reply within a week, he shall treat the offer as accepted. That means the offer has a term, the non-compliance of which would amount to acceptance. So this is what provision we will write. Is it a valid offer? No, it's not a valid offer because offer cannot contain a term, the non-compliance of which would amount to acceptance. So is A correct in his proposition? No, the offer is not valid. What will be the position if B communicates? Doesn't matter if B communicates or not. The offer itself is not valid. So how can the acceptance be valid? A shopkeeper displayed a pair of dress in the showroom and a price tag of 2000 was attached to the dress. Miss Lovely looked at the tag and rushed to the cash counter. Then she asked the shopkeeper to receive the payment and pack up. Just 1 second, guys. To receive the payment and pack up the dress. The shopkeeper refused to hand over the dress to Miss Lovely in okay, first of all, it's a price tag. Price tag is what? Invitation to offer, right? Was attached. Miss Lovely looked at the tag and rushed to the cash counter. Then she asked the shopkeeper to receive the payment and pack up the dress. The shopkeeper refused to hand over the dress. Okay, my question is, can the shopkeeper actually refuse to hand over the dress? Yes, because it's an invitation to offer. And an invitation to offer, I am not bound to sell. So, shopkeeper refused to hand over the dress to Miss Lovely in consideration of the price stated in the price tag attached to the dress. Miss Lovely seeks your advice whether she can sue the shopkeeper for the above cause. Can she sue the shopkeeper for the above cause? No. Why not? Because it is just an invitation to offer. Shambhu Dayal started a self-service system. Self-service system is again an invitation to offer. Held in the case of Pharmaceutical Society of Great Britain versus Cash Boot Chemist. System in his shop, Srimati Prakash entered the shop, took a basket, and after taking articles of her choice into the basket, reached the cashier for payment. The cashier refuses to accept. Okay, can he refuse to accept? Yes, because it's an invitation to offer. Can Shambhu Dayal be compelled to sell the said article to Srimati Prakash? Can he be compelled to sell? No. Invitation to offer. I am not bound to sell. Beside, as per the provisions of Indian Contract Act. Clear? Please keep your answers popping up. You should have an answer the moment we start discussing the questions. A mobile phone was displayed in a shop with a price tag. Again, price tag. Same question. Price tag is what? Invitation to offer. Correct? And an invitation to offer, I am not bound to sell. Attached to the mobile display box. As the price displayed was very less as compared to the MRP of the mobile phone, why a customer rushed to the cash counter and asked the shopkeeper to receive the payment and pack up the mobile phone. The shopkeeper refused to hand over the mobile phone to Y in consideration of the price indicated in the price tag attached to the mobile phone. Can he actually refuse? Yes, because it's just an invitation to offer. Yeah, because it's just an invitation to offer. Y seeks your advice whether he can sue the shopkeeper for the above cause under the Indian Contract Act. No. Why? Because it was just an invitation to offer. And in invitation to offer, you will have no remedies. Mr. Asim is a learned advocate. His car was stolen from his house. He gave an advertisement in the newspaper. Advertisement in the newspaper is what? Advertisement in the newspaper is what? Invitation to offer. Correct? That he will give a reward of 10,000. Now there is a reward money. Advertisement is invitation to offer. But if there is a reward money, then it becomes an offer. Correct? If there is a reward money, it becomes an offer. A reward of 10,000 who will give the information about his car. Mr. Vikram reads the advertisement and on making some efforts got the stolen car and informed Mr. Asim. Mr. Asim found his car but denied giving reward of 10,000 to Mr. Vikram. With the words, an advertisement in newspaper is he correct? No. An advertisement is an invitation to offer. But if there is a prize money, it is an offer. If there is a prize money, it is an offer. Correct? So, and hence he is not liable to make the reward. Is he liable to make the reward? Yes, he is. State with reasons whether under the Indian Contract Act, Mr. Vikram can claim the reward. Yes, he can. So basically, what will you write? You will write about invitation to offer. And then you will write that invitation advertisements are invitation to offer. But if the advertisement has a prize money, it is an offer. That is what provisions you will write here. Rahul goes to a supermarket to buy a washing machine. Supermarket to buy a, this is again invitation to offer. Correct or not? Question is almost the same. Don't want to do it, but still it's there, we'll do it. He selects a branded washing machine having a price tag of 15,000 after a discount of 3,000. Rahul reaches at the cash counter for making the payment, but the cashier says, "Sorry, sir, the discount was up to yesterday. There is no discount from today. Hence, you have to pay 18,000." Rahul got angry and insists for 15,000. This is a discount. Okay, here it is a discount. And again, when I say discount, it's an invitation to offer. So if he sells at 15,000, fine. But if he claims 18,000, can he claim it? Yes. Rahul can enforce the cashier to sell at the discounted price. No, because discount is an invitation to offer, and the seller has a right to claim the whole price and not just the discounted price. So again, here also you will write about what? Invitation to offer. Right? You will write about invitation to offer. Mr. Pratham applied for a job to the principal as a principal of a school. The school management decided to appoint him. So it is made it is what? It is a special offer. One member of the school committee privately informed Pratham that he was appointed. This was informed privately. So when I say it was privately informed, that means what? Did you actually see the offer was made to the committee? Okay, who has a right to accept the committee? This person is a member of the committee. He was told by the committee, please go and tell Pratham we accept his offer. Would it be valid? Yes. But did they tell him? No, he privately communicated. Is it a valid communication? No. In case of special offer, the offer can be accepted only by the person or group to whom the offer is made. Mr. Pratham that he was appointed, but official communication was not given from the school. Later, the management of the school decided to appoint someone else as the principal. Mr. Pratham filed a suit against the school for cancellation of his appointment and claimed damages for loss of salary. Can he do that? No. State with reasons, will he be successful? No. And why will he not be successful? Why will he not be successful? Because the offer was never accepted. If they would have accepted it, then he could have claimed, but the offer was never accepted. But ma'am, he was communicated. It was not a valid communication. Mr. B makes a proposal to Mr. S by post to sell his house for 10 lakh and posted the letter on 10th April 20. And the letter reaches S on 12th April 20. He reads the letter on 13th April. So on which date the offer made by B will complete? It will complete on 13th April. Correct? Mr. S sends his letter of acceptance on 16th and the letter reaches B on 20th. On 17th April, S changed his mind and sends a telegram withdrawing his acceptance. So he changed his mind and he sent a telegram withdrawing his acceptance, which reaches on the 19th. The acceptance letter reaches on the 20th. Revocation reaches on 19th. Is the revocation valid or acceptance valid? Revocation is valid if it is received before the acceptance letter. Here, before the acceptance letter, we have received the telegram of revocation. So is the acceptance valid or revocation valid? Revocation is valid. So what is the validity of the acceptance? Not valid, it is revoked. What would be the validity of the acceptance if letter of revocation and letter? So when letter of revocation and when letter of revocation and letter of acceptance reach together, then in that case the revocation is absolute. And when I say absolute means you cannot question the validity of the revocation is valid. So again, acceptance is not valid. The revocation is absolute. Ramaswamy proposed to sell his house to Ramanathan. Ramanathan sent his acceptance by post. Next day, Ramanathan sends a telegram withdrawing his acceptance. Examine the validity of the acceptance according to the Indian Contract Act. The telegram of revocation was received before the letter of acceptance. Obviously, what is valid? Acceptance is not valid. He is asking you, examine the validity of acceptance. Okay, acceptance is not valid. Why is it not valid? Because we have received both the letters together. We have received the revocation first. The telegram of revocation and letter of acceptance both reached. When both reach together, the revocation is absolute. And when I say revocation is absolute, that means acceptance is not valid. Correct? Acceptance is not valid. M offered to sell 25 chairs to B at 1500 per chair on 12 to 24. A promised that the offer will be open till 15 to 24. Standing offer. This is what? Standing offer. Correct or not? Standing offer. However, on the 13th of Feb, he sold those shares to Mr. C at 1700 without the knowledge of B. So, in case of, I repeat again, in case of standing offer, if in the meantime the offer is made to another person, it's an automatic revocation of the offer. So, B communicated the acceptance of the offer on is it valid? No. The moment he made the offer to C on 13, it's an automatic revocation of this offer. Now, when he accepts it on 14, is it a valid acceptance? No, it's not a valid acceptance. So, whether B can claim damages from A? No, the offer has already been revoked. Okay, if my question is of 2 marks, how am I supposed to write? Always there for you all. I just hope that your results are amazing, your paper goes well. Just want that, nothing else. Okay. One thing, tell me. I was actually talking about this one. Huh. If the question is, thank you so much. So tell me one thing. I have a question here. So basically, my question is that if it is a 2 marks question, do I write so big, so huge? No. If it is a 2 mark question, write the provision or write the conclusion and write the provision. That's it. Or write the provision, just little basic description of the case and the answer. It will be obviously comparatively much smaller than if it is 3 or 7 marks. If it is 7 marks, your provisions will be more elaborate. Okay. And one more thing, if there are, more than one provision or even the same provision has multiple points, even if you're not writing it in number, kindly go to the next line and write the next part of the provision. Don't write it in the same line. It's cleaner. It's more presentable when you do like that. Keep these things in mind. So with this, we are done with you. That's okay. That's okay. So we are done with unit 2. Now coming to unit 3. See, we have already reached unit 3. You won't even realize and the scanners are over, Swift scans are over. And, solving question is, I told you, you have so much of time, you should definitely solve questions. So moving on, Unit 3, Mr. Balwant, an old man by a registered deed of gift, granted certain landed property to Mrs. Reema, his daughter. By terms of the deed, it was stipulated that an annuity of 20,000 should be paid every year to Mr. Sawant, who was the brother of Mr. Balwant. On the same day, Mrs. Reema made a promise to Mr. Sawant and executed in his favor an agreement to give effect to the stipulation. Miss Reema failed to pay the stipulated sum. Okay, first of all, and Mr. Sawant, she contended that since Mr. Sawant had not furnished any consideration, he has no right of action. This is based on the rule of Chinaya versus Ramaya. So, in the case of Chinaya versus Ramaya, even if the promisee is not giving you any consideration, the third party has given consideration, which acts as consideration from the promiser. Here, promiser is who? Promiser is Miss Reema. She makes the promise to Mr. Sawant, promisee. Sawant is not giving any consideration, but Mr. Balwant has given consideration for this contract. So when a third party has given consideration, the contract is absolutely valid. So now tell me, decide whether the contention of Miss Reema is valid. What is Miss Reema's contention? She said that since Mr. Samant had not furnished any consideration, he has no right of action. Does he have a right of action? Yes, because Mr. Balwant had given the consideration for this contract. So is a contention valid? Not valid, because consideration can move from the promisee or any other person. And even if the consideration moves from the third party, it is absolutely valid, right? Now, the next one, Mr. Sohan Lal sold 10 acres of his, on this, whatever someone had written this comment about the language. You don't have to write the law, for language. Technical words are sufficient. But yes, here, one thing is very important. When I say don't have to write in the law language, that's fine. But some of you write such layman language, you will not get marks if you write such layman language also. It has to be a little standardized, a normal English, at least a standardized English should be there. Mr. Sohan Lal sold, yes, correct. Mr. Sohan Lal sold 10 acres of his land, to Mr. Mohan Lal on 25th September 2018 for 25 lakhs. The property papers mentioned a condition amongst other details that whoever purchases the land is free to use 9 acres as per the choice, but the remaining 1 acre has to be allowed to be used by Chote Lal, son of seller, for carrying out farming or other activity of his choice. On 12th October, Mr. Sohan Lal died, leaving behind his son and this is wife actually, life, whatever. On 15th October, purchasers started construction of an auditorium on the whole 10 acres. He was actually supposed to use only 9 acres, but he started using all the 10 acres. Here, there was a contract between Sohan Lal and Mohan Lal. But in this contract, Chote Lal was named as a beneficiary for the 1 acre of land. Correct or not? So now they are saying and denied. Now Mr. Chote Lal wants to file a case against the purchaser and get a suitable redressal. So basically, how will you identify? Contract is between Sohan Lal and Mohan Lal. He is a beneficiary and he wants to enforce the contract. This is what? Suit by a third party. Correct? This is suit by a third party. And because the question is about land, it is what? Covenants running with the land. And one more thing, whenever you have a question which is based on the locha of a rule, okay? Yes. When the question is based on the locha of a rule, make sure that you are, what do you say? You are at least quoting first, you are quoting the provision of the rule. That is, third party cannot sue. Make sure you write that. Then you write, however, there are certain exceptions to this rule, and then you write the exception, right? Chalo, moving on to the next question. Father promised to pay his son a sum of rupee 1 lakh if the son passed the CA exams in the first attempt. The son passed the examination in the first attempt. So, okay, father promised to pay his son a sum of rupees 1 lakh if son passed the CA exam. So, first of all, can I say it's a relationship between father and son? Right? So, can we say there is a domestic agreement between them? Yes. And the father is giving money to his son, but is the son giving anything in return? No, the son is not giving anything in return. So that means what? There is no consideration also. Now, tell me one thing, if this agreement was written and registered, then would it be a valid contract? Yes, absolutely, it would be a valid contract. So the son passed the examination, but father failed to pay the amount. Failed to pay the amount as promised, son files a suit for recovery of the amount. State along with the reasons whether the son can recover the amount under the Indian Contract. Can the son recover the amount under the Indian Contract Act? No. Why? Because there is no legal relationship. Yes, you have to write about natural love and affection, and also there is no consideration. But tell me, if in this case they would have given, it was written and registered, then it would have been a valid contract or not? Yes, then it would have been a valid contract. Moving forward, Mr. Ramesh promised to pay 50,000 to his wife, Mrs. Lali, so that she can spend the sum on her 30th birthday. Mrs. Lali, so he promised, he did it out of his, excuse me, excuse me. He did it out of his choice so that Mrs. Lali can spend the sum on her 30th birthday. Mrs. Lali insisted her husband to make a written agreement and the agreement was registered. So this contract was made out of love and affection. It was written and registered, right? So Mrs. Ramesh failed to pay the specified amount. Can Lali file a suit against Ramesh and recover the promised amount? Yes. There is a domestic relationship, but since this agreement was written and registered, it becomes a valid contract. Is Ramesh getting anything in return? No, so there is no consideration also. But still, because it's written and registered, the contract is a valid contract. Mr. Ramlal Birla was a big businessman of city Pune, having two sons and one married daughter. He decided to gift his house to his daughter. For this purpose, he called. Okay, he is gifting. So, is he getting anything in return? No. So, there is no consideration in this contract. And also, it is made between father and daughter. That is, it is out of what? It is domestic agreement. For this purpose, he called his lawyer at his house and made a written document for such gift. The lawyer advised him to get the transfer. Yes, Aditya, correct. To get the transfer document properly registered. Keep dropping in your answers. You're not sitting there. It's too boring. And the time is 2 o'clock. Just had my lunch. Oh my God, the best time. Ma'am's voice is like, I know my voice is very sweet. It's like lullaby. And I want answers to keep popping in. Okay. So where they when they both were going for registration of documents. So see, please, how will I identify? Here it's a domestic relationship between father and daughter, correct or not? He is gifting it to her, so there is no consideration between them. When they both were going for registration of document, they met with an accident and both of them died. Later, his daughter found the document and claimed the house. Can she claim the house? No. Why? Because it was never registered. So what point will I write? There is no consideration to Mr. Ramlal, so it's no consideration, no contract. It is domestic, so it's natural love. Ma'am, it could be completed gifts also. Yeah, because they have used the word gift. But here, please tell me, in completed gifts, you are making a promise to gift. Did Mr. Ramlal promise the gift to his daughter? No. So it is natural love and affection. Mr. A was running an orphanage. His friend S, a philanthropist, agreed to donate 2 lakh for the treatment of a child who was suffering from cancer. So this is what? Donation. In donation, do I get anything in return? No. Again, no consideration, no contract. A promise to give donation, is it enforceable? No. A promise to give donation is not enforceable. On emergency, Mr. A incurred 1.5 lakh on the treatment of the child. Now, Mr. S refused to pay. Whether Mr. A can claim 1.5 lakh. A promise to give donation is not enforceable. But if on the basis of the promise, the other person has incurred any liability, can he recover to the extent of liability incurred? Yes. Can they recover? Yes. 2 lakh or 1.5? 1.5 was the expenditure. So 1.5. Chalo, with this, we are done with unit 3. Unit 4, which is the lengthiest of all the units. So we are going to start with unit 4 now. Suicide, is it coercion? Yes. Under the Indian Penal Code, it's punishable, though now they don't make it punishable, but you will see in the ICAI book it's written it's coercion. So, yes, it's coercion. Yes, exactly. Okay. So, moving on to the next part, unit 4, which is other essentials. This unit basically covers all the other essentials that we have. So, what are these other essentials that we have? Chotu of 17 years has purchased a mobile of 25,000. So this is about minor of 25,000 for his online classes. That means this is what? Necessaries, correct? From mobile sales center on credit. On due date, he did not make the payment of the mobile. Mobile sales center sued Chotu and his parents for the price of the mobile. Chotu has 15,000 as his cash balance, right? First of all, this is necessaries. In case of necessaries, the minor is never personally liable. The liability is against his property. Parents of a minor are liable only when they have given an authority. Here, did they say anything about parent giving authority? No, nothing was given. So obviously, this so not even they are not even liable. Now, Chotu has 15,000 as his cash balance, but his father has enough money to pay the price. Father is not liable because he never gave the authority. How much Chotu has? 15,000. Liability is against the minor's property. So, can we say 15,000 can be recovered from here? Yes. Who will be liable to pay the price under the provisions? Only Chotu's property is liable up to 15,000. The parents are not liable. Ayush, who's a minor, purchased 10 fancy coats for the wedding ceremony of his sister on credit. Correct, Aditya. Very nice. Uh, for the wedding ceremony of his sister on credit from Messrs. Surjewala and Sons. The cost of all the coats was 80,000. Not even a single coat was a necessity. Never miss out these words. Once I was discussing this in the class, they said we can recover all the 10. And they did not read this line. Please, this line gives you the answer. It's not a necessity. So if it is not a necessity, are you liable to pay? A minor is liable to pay only for the necessaries supplied to him against his property also. Not he's personally liable. Liability is also against his property. Here, not even a single court was a necessity. Ayush has assets of 1 lakh. Mrs. Surjewala filed a case against Ayush for recovery of 80,000. Following the provisions, is he liable to pay 80,000? Absolutely no. Why? Because it is not a necessity. Ex a minor was studying in MCOM. Now, half of my students, instead of thinking the answer, they will be like, how can the minor be in MCOM? Let it be. How does it matter? He MCOM nahi. He might be, he might be 17 years old looking like a 60-year-old. How does it matter to you? You just answer the question. In a college, on 1st July 2019, he took a loan of 1 lakh from B for the payment of his college fees and to purchase books and agreed to repay by 31st December. Okay. He took a loan of how much? 1 lakh. He took a loan of 1 lakh for the payment of his college fees and purchase books. Can we say this is necessaries to the minor? Correct or not? Yes. And agreed to repay by 31st December 2019. Correct, Aditya. X possesses assets worth 9 lakh. On the due date, X fails to pay back the loan. B now wants to recover the loan from X's assets. Can he recover? It is necessaries. Yes. Can he recover? Yes. Is the money sufficient to cover the loan amount? Yes. He will recover the full 1 lakh. Mr. Shekhar wants to sell his car. For the purpose, he appoints Mr. Nadan, a minor, as his agent. Can a minor act as an agent? Yes, it's absolutely valid. And if the agent is a minor and he does any act, the act is absolutely valid. Mr. Shekhar instructs Nadan that should be the car should not be sold at a price less than 1 lakh. So he says minimum 1 lakh is the price of the car for sale. Nadan goes and sells off the car to Masoom at 80,000, right? And sells the car for 80,000. Explain the legal. Can Shekhar recover the loss from Nadan? No. If he was not a minor, he could have recovered. But since he's a minor, when the agent is a minor, the agent is not liable to the principal for the acts done. Mr. Shekhar can recover his car. No, minor can be an agent. And if he is an agent, any act done by him is valid. Any act done by him is valid. So here, when he sells off the car, the sale is absolutely valid. That means M gets the title to the car. So can he recover the car? No. Rahul, a minor, falsely representing his age, enters into an agreement with the shopkeeper for a loan amount for purchasing a laptop. He gave his expensive watch as a security and took a loan of 40,000. He was very happy to get 40,000 and quickly went to the market and purchased the laptop worth 30,000. He happily spent the rest of the amount with his friends on a pleasure trip. Later on, Rahul realized that his watch was an expensive watch and he should not have given it to the shopkeeper. So he went to the shopkeeper and asked for his watch back. Also, he refused to repay the loan. The shopkeeper files a case. When a minor fraudulently enters into a contract and the contract is taken to the court, the case is taken to the court. He can prove his minority and the contract is discharged. But if his intention is to cheat, that is, if the contract is cancelled at the instance of the minor, even if he proves his minority, he will have to compensate. Here he wants to cancel, but he refuses to repay. He is only cancelling, so he will have to compensate. Yes. Now, here, when I talk about compensation, can I ask him to pay the 40,000 rupees? No, that is already spent. It is spent in 30,000 का लैपटॉप 10,000 का लीजर ट्रिप. That 10,000 का leisure trip, the money is gone. This 30,000 ka money ka laptop. I don't have the money, but I have the laptop. So can the shopkeeper get the laptop? Yes. So see, but court can be ordered to return the laptop to the shopkeeper. Shrishti, a minor, falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Gupta, owner of SP Laptops, for purchase of laptop on credit amounting 60,000. For purchasing laptop on 1st August. She's a minor, so minor's agreement. She's falsely representing her age, right? Mr. Gupta, owner of she promised to pay back the outstanding amount with interest. She told him that in case she won't be able to pay, her father, that means parents, will pay back on her behalf. After 1 year, when Shrishti was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she's a minor and now he can't recover a single penny from her. She will be adult and only after that the agreement can be ratified. Explain so I can see. See, when there are multiple provision, you have to be very sure which one should come first, which one should come later. Here you can see multiple provisions. Minor is there, parent of a minor is there, ratification is there. Now, instead of writing first about minors agreement is void, you first write Minors Act cannot be ratified. Now, honestly, you tell me if you do this, is it correct? If you do this, is it correct? They are, I mean, does it, I mean, I'm not saying it's wrong, but don't you think it's a little haphazard? The whole, it's like, Bangalore roads. You understand what I'm trying to say? Please don't make it like that. Right? It should be first you talk about minors agreement is void and then you talk about it cannot be ratified. You cannot write first. So, whenever there are multiple provisions, please make sure that you are writing it in a proper sequence which makes a connection to each other. So, explain by which of the following ways Mr. Gupta will succeed. If he files a so here, the case was never, the case never went to the court. They are asking what is it. So you can never talk about minors pleading minority. That doesn't even come here because the case never went to the court. Only when it goes to the court, after that comes pleading. So by filing a case against minor for recovery of the outstanding amount with interest, also she never refused to pay. She said, I'll pay after I become a major. So she's not cancelling the contract. So by filing a case against Srishti, no. Why? Because a contract with a minor is void ab initio. By filing a case against Mr. Ram, no. Why? Because parent of a minor is liable only for the act they have given authority. Here, the parent had never given the authority to buy the laptop. By filing a case against Srishti, a minor, for recovery of outstanding amount after she attains majority, no. Why? Because Minors Act cannot be ratified, right? Minors Act cannot be ratified. I hope it's clear to all of you. I think this is the last question of minor, if I'm not wrong. Yeah. Moving on to the next one. A student was induced by his teacher to sell his brand new car to the latter at less than the purchase price to secure more marks. There is a relationship, there is a dominating position which I'm using to make a contract which is very unfavorable. This is what? Undue influence, right? However, the father of the student persuaded him to sue his teacher. State on what grounds the student can sue the teacher. Can he sue the teacher? Yes, because the contract is voidable and the contract is induced by undue influence. Please remember, under the Indian Contract Act, the contract is voidable only in 3 cases, right? When the consent is not free. That is coercion, undue influence, fraud, misrepresentation. Second, when the time is of essence. And the third one party is ready to perform but other refuses to accept. That is effect of refusal to perform or anticipatory breach or attempted performance, whatever you call it, right? I mean, sorry, I'm saying anticipate. I'm so sorry. Attempted performance or effect of refusal to perform or breach, not just anticipatory. In all of these 3 cases, contract is voidable. When I say void, contract, under Indian Contract Act, contract is void only in 2 cases. First is supervening or subsequent impossibility. And the second one is contingent contract. The rest all is what? Void ab initio, right? Mr. A, the employer, induced his employee, undue influence, without even reading the rest, we can say. Mr. B to sell his one room flat to him at less than market value to secure promotion. There is a relationship, there is a dominating position. I'm using it to make a contract which is unreasonable. Examine the validity of the contract. Okay. So say Mr. B sold the flat to Mr. A. Later on, Mr. B changed his mind and decided to sue Mr. A. Can he do that? Yes, because the contract is what? Voidable. Examine the validity of the contract as per. The contract between A and B is voidable at these options. So B can actually cancel the contract. Chandan was suffering from some disease and was in great pain. He went to Dr. Junjunwala, whose contribution fees was sorry. I'm so sorry. What am I reading? His consultation fee was 300. The doctor agreed to treat him, but on one condition that Chandan had to sign a promissory note of 5,000 payable to doctor. Patient and doctor. Patient and doctor. There is a what? First of all, there is a relationship, there's a dominating position, unreasonable sum of money, right? Chandan signed the promissory note and gave it to the doctor. On recovering from the disease, Chandan refused to honor the promissory note. State with reason, can the doctor recover the amount? No. Why? Because the contract is what? Voidable, right? Contract is voidable. Explain the type of contract in the following agreement under the Indian Contract Act. X promises to sell his scooter to Y for 1 lakh. However, consent of X has been procured by Y at gunpoint. Gunpoint is what? Coercion. And coercion may the contract is what? Voidable. Karan agreed to purchase wooden table for his study room from X. Table was in good condition and it was examined by Karan before purchasing. He found no defects. So here, tell me one thing. Was he negligent in examining? Or he had examined it carefully, but he found no defects. He had examined it carefully, he found no defects. And it paid 20,000 for that table. Later on, it was found that one leg of the table is broken and X has pasted the wood and tried to hide the defect. Can we say this is fraud? Yes. Can Karan return the table and claim the amount back? Yes. Why? Because it is fraud, and in fraud, the contract is voidable. But, ma'am, he had diligence, no? No, they never said that he was not careful in examining. He examined it carefully. He couldn't see it. That means it was not visible to the eye. And this means what? It was not visible to the eye. Correct? Kapil went to a departmental store to purchase a steel pan. He asked the salesman about the area in the departmental store where steel pans are kept. The salesman indicated him the area with instructions that with steel pans, other metal pans were also kept. He had already told him this. Kapil wrongfully picked an aluminium place in place of steel pan. The salesman watched but said nothing to Kapil. Silence is not fraud. Correct or not? Silence is not fraud. Kapil reached his house and found that pan was not a steel pan but actually an aluminium pan. Kapil filed a suit against the departmental store for fraud. Is it fraud? No. Decide whether Kapil was eligible to file the case. No, this was not fraud. Silence is not fraud. He already told him that along with steel pans, there are other pans. His obligation was already done. P sells by auction to Q a horse which P knows to be unsound. The horse appears to be sound, but P knows about the unsoundness of the horse. Is this contract valid in the following circumstances? In auction sale, I don't have to tell you anything about the goods. It's there on display. You like, you purchase. It's totally your choice. Correct or not? It is totally your choice. If P says nothing about the unsoundness of the horse to Q, contract is valid. Why? Because silence is not fraud. Why is the contract valid? Because silence is not fraud. If P says nothing about it to Q, who is P's daughter and who has just come of age. Just come of age means she's just turned 18. Silence is not fraud. But you know what happens? Where in a contract, the contract is made, okay. Hello, Yash. Where in a contract, the contract is made between family members. Like, actually, in case of auction sale, I don't have to tell you anything. The goods are on display. You like, you purchase, totally your choice. But if any of my family members come there, in that case, I am liable to disclose all the facts. And if I don't, it's fraud. So if P says nothing about it, then it is voidable. Why? Because Q is P's daughter, where it is the duty of the person keeping silent to speak. If Q says to P, if you do not deny it, I shall assume that the horse is sound. P says nothing. Here, when P says nothing, his silence amounts to acceptance that yes, the horse is sound. The contract is again voidable. Why? Because silence equals to speech, right? Sohan induced Suraj to buy his motorcycle, saying that it was in a very good condition. After taking the motorcycle, Suraj complained that there were many defects. So, this could be fraud or this could be misrepresentation. That is, you have given me wrong information. Sohan proposed to get it repaired and Acha, so there were many defects. That means what? This is voidable. Fraud or misrepresentation. It is what? Voidable, right? Sohan proposed to get it repaired and promised to pay 40% of the cost of repairs. We don't know he accepted it or not, but if you look forward, after a few days, the motorcycle did not work at all. This shows what? This shows that afterwards he accepted. Okay, that means he had the motorcycle, he accepted the cost of repairs, and after that, the motorcycle completely breaks down. Now, Suraj wants to rescind the contract, decide giving reasons. First of all, it was a voidable contract, he could have actually cancelled it. But when he accepts the cost of repairs, it was a voidable contract which he has now ratified. By accepting the cost of repairs, he has accepted the contract. Now the contract is what? Valid. So do you think now he can cancel the contract? No. So he wants to rescind the contract. No, he cannot rescind the contract. The contract is absolutely valid. He can only recover the 40% of the cost of repairs, but he cannot return the motorcycle back. He had a right to return it back, but when he accepted that money, no, he cannot. Yes, Praveen, what happened? Anything, any problem, guys? Mr. Samant owned a motor car. Mr. Samant owned a motor car. He approached Mr. Chotu and offered to sell the motor car for 3 lakh. Mr. Samant told Chotu that the motor car is running at the rate of 30 kilometers per liter of petrol. Both the fuel meter and the speed meter of the car were working perfectly. Chotu agreed with the proposal of Samant and took delivery of the car by paying rupees 3 lakh to Mr. Samant. After 10 days, Chotu came back with the car and stated the claim made by Samant regarding fuel efficiency was not correct. That means he had made a wrong information, given a wrong information. Now, here two things can happen. The wrong information can be given either by knowingly or unknowingly. If it is knowingly, it's fraud. If it's unknowingly, it's misrepresentation. And therefore, but he's saying it's a case of misrepresentation. So don't sit and think, are you fraud or misrepresentation? He's saying it's misrepresentation. Khatam. Now, he made a wrong what? He made a wrong information. He made a wrong statement about the fuel efficiency. So this is misrepresentation. But and in case of misrepresentation, the contract is what? Voidable. Correct? But if you look here, it says both the fuel meter and the speed meter of the car were working perfectly. Both the fuel meter and the speed meter of the car were working perfectly. This shows what? That if Chotu would have checked it, he would have found the correct information. Correct or not? That means here Chotu had means to discover the truth. So Yes, it was misrepresentation. If he would have used this diligence, he would have come to know the facts. So, where in a contract, if it is induced by fraud or misrepresentation, the contract is voidable. But the other party, if he could have used this diligence, would have come to know the facts. Would have come to know the facts. In that case, the contract is absolutely valid. So, can Mr. Chotu rescind the contract? No, the contract is absolutely valid. Mr. Y is a devotee and wants to donate an elephant to the temple as a core part of ritual worship. He contracted Mr. X, who wanted to sell his elephant. Mr. X contracted with Y to sell his elephant for 20 lakh. Both were unaware that the elephant was dead a day before the agreement. Can we say initial impossibility? Yes. Can we say bilateral mistake of existence of subject matter? Yes. This is also known as what? Initial impossibility. The contract is what? Void. Whether it is void, voidable, or valid, it is what? Void. Great guys, keep giving answers. Don't sit there not doing anything, not giving any answers. Don't do that. Mr. X, a businessman, has been fighting a drawn litigation with Mr. Y, an industrialist. To support his legal campaign, he enlists the services of Mr. C, a judicial officer, stating that the amount of 10 lakh would be paid to him if he does not take up the brief of what? Mr. Y. Interference with the course of justice, sale of public offices, yes. Mr. C agrees, but at the end of the litigation, X refuses to pay C. Decide whether C can recover. Okay, C can recover the amount promised by X. No. Here, what is happening is he is bribing to get a work done. So, this is what? Against public policy. Correct or not? So, the consideration is not lawful. Also, it was done with the interference with the course of justice. So, it's void. Sometimes, you get a question like this question, you'll be like, what provision will I write? Sometimes it happens, in exam, you get a question where you're like, I don't know what provision should come here. Weird question it is. Sometimes it happens. You can expect one question like that if it happens also. So it's okay, chill. Aisa, you cannot get all the, best easy questions. Mr. S, aged 58 years, was employed in the government department. He was going to retire after 2 years. Mr. D made a proposal to Mr. S to apply for voluntary retirement from his post so that D can be appointed in his place. D offered a sum of 10 lakh as consideration to which Mr. in order to induce him to retire. Mr. That means he is saying, I will give you money, you please retire from your job so that I get the post that you have. Mr. A refused at first instance, but when he evaluated, so it's a government department, I am giving you money to quit your job so that I can get the job. It is what? Sale of, yeah, public offices. Correct or not? Mr. S refused at the first instance, but when he evaluated the amount offered as consideration is just double of his cumulative remuneration to be received, he agreed to receive the consideration. Whether the agreement is valid? No, it is void. Why? Because it is sale of public offices, right? Against public policy. X agreed to become an assistant for 2 years to Y, who was a practicing CA at Jodhpur. Correct, guys, correct. It was also agreed that during the term of agreement, X will not practice as a CA on his own account within 20 kilometers of the office of Y at Jodhpur. At the end of 1 year, X left. Now, here, if they would have just said, till you are working for me, you cannot, then it's different. But here they said, for 2 years, you cannot work anywhere else. So, because this 2 years is given, he cannot do the same work for 2 years. Right? So, X left the assistantship of Y and started practicing on his own account within the said area. At the end of 1 year, he left and started. Can we stop him from doing? Can X be restrained from doing so? Yes. Can X be restrained from doing so? Yes. Why? Agreement and restraint of trade. Agreement and restraint of trade is void. But if the restraint is reasonable, it is valid. Here, because you were working for me, I have put this restraint, it's absolutely valid. Kashish was running a business of artificial jewelry since long. He sold his business to Naman and promises he was carrying artificial jewelry and promises not to carry the business of artificial jewelry and real. Okay, I have sold the goodwill of my artificial jewelry. Can I stop you from doing the same business? Yes, valid. But can I stop you from doing the real jewelry business? No. Is it valid? No, this is not valid. Correct? This is not valid for real diamond jewelry. Naman filed a suit against Kashish for closing the business of real diamond jewelry business. Okay. After 2 months, Kashish opened a showroom for real diamond jewelry. Naman filed a suit against Kashish for closing the business of real. Can he sue? No. No. Why? Because Kashish, Kashish has a right to carry the real business. See, please understand. When it is a reasonable restraint, it's valid. I have sold you the business of artificial jewelry. You can stop me from doing that, but real is different. You cannot. So, this contract, can I say it's partially valid and partially void? Yes. So, whether Kashish is liable to close his business? No. Kashish can carry the business. Kashish can continue his business. Rohan is running a grocery store in Delhi. He sells his grocery business, including goodwill worth 1 lakh to Rohit for a sum of 5 lakh. After the sale of goodwill, Rohit made an agreement with Rohan. As per this agreement, Rohan is not to open another grocery store in the whole of India for the next 10 years. Okay. Now tell me one thing. He had a grocery store. The agreement says you cannot open any grocery store in the whole of India. It's a grocery store. You are telling me cannot open any grocery store in the whole of India. You tell me one thing. Is it even possible? Huh? Is it even, do you think it's reasonable? Not at all reasonable. So, however, Rohan opens another store in the same city 2 months later. Right? What are the rights available with Rohit regarding the restriction imposed on Rohan? No rights. He cannot sue. Why? Because the contract is void. Why is it void? Because it is unreasonable. Yeah, the restrictions are not valid. Clear, all of you? Yes? State with reasons. After this unit is done, I just need a 2 minutes break just to, stop talking. Okay? Just take 1 or 2 minutes break, but I just need that 1 minute break. State with reasons whether the following agreements are valid or void. A clause in a contract provided that no action should be brought upon in case of breach. You are saying no action. That means you are prohibiting, correct or not? Agreement in restraint of legal proceedings is what? Void. Where two courts have jurisdiction to try a suit. An agreement between the parties that the suit should be filed in one of the courts alone and not in the other. We have two courts can take your case. Okay. We are saying that we will not go to this court, we will only go to this court. So we have restricted that we will only go to one court. Is it prohibition or is it restriction? It's restriction. Like, for example, we say we will not go to the court, we will go to the arbitrator. Is it valid or not? Absolutely valid. Here we are not prohibiting you from going to the court. We are just restricting, we will only go to this court. X offers to sell his Maruti car to Y. Y believes that X has only a wagon car but agrees to buy it. The agreement is not clear, right? Uncertain terms. The contract is what? Void. Why is it void? Because the two parties are thinking about different things. No consensus ad idem. X, a physician and surgeon, employs Y as an assistant on a salary of 75,000 for a term of 2 years, and Y agrees not practice as a surgeon and physician during these 2 years. Valid? Valid. Because agreement in restraint of trade, if it is reasonable, it is absolutely valid. A enters into a contract with B that he sells his house for 10 lakh to B. Further, they both signed an agreement that if B uses the house for gambling purpose, then B shall pay A 50,000 for it. Is this valid? Yes. Is this valid? No. Why? Because it is gambling. B agreed for this. However, after a year of sale, B started gambling business in that house. Can A claim 50,000 from B? No. Why not? Because it was void. Why void? When a part of the contract is unlawful and it is separable, the unlawful part is void. So this is valid 10 lakh, but this 50,000 is void. Mr. Ayush is the principal in modern public school. He needs 2,000 packets of biscuits to be distributed to students in his school on the occasion of Republic Day celebration. For this purpose, he contracted with Yograj Biscuit Company. Mr. Ayush visited the workshop of Yograj Biscuit Company and was very much satisfied with the quality of biscuits. He also found that a large number of varieties of biscuits are manufactured in the workshop. He ordered 2,000 packs of biscuits and gave the token money but did not specify the category of biscuits. The terms are what? Uncertain. Because they manufacture a variety of biscuits, and here he did not specify the category of biscuits. So, state with reasons whether Yograj Biscuit Company is liable. No. Mr. Ayush filed a suit against Yograj for compensation. No, because you never told me which biscuit you want. So, because the contract terms are uncertain, this contract itself is void. And when it is void, how can you sue me? Okay, with this, we are done with this. We'll start Unit 5. Give me just 2 minutes and then we'll continue with Unit 5. Okay, so let's move forward to the next unit, that is Unit 5. Two more units are left, and special contracts, I've already uploaded it. You must have seen it also. So, coming to Unit 5 ka questions. Mr. S promises M. So, this is one unit, no, when they actually ask a lot of questions. I'm not telling it will come for your exams because so much of syllabus is there. So, it's quite scattered what can come. So, Mr. S promises Mr. M to paint picture. I hope all of you are back. to paint picture for Mr. M to paint a family picture for 20,000 and assures to complete his assignment by 15th March. Unfortunately, S died in a road accident and his assignment remains undone. Okay, it's a paint a family picture. It is based on what? Personal skill. Correct or not? Based on what? Personal skill. Now, Mr. S died. Death of the promiser. The contract will be what? Discharge. Why? Because it is based on personal skill. I cannot ask the legal heirs to perform. So, can Mr. M bind the legal representative of S for the promise made by S? No. Why? Because it is based on personal skill and confidence. Suppose S had promised to deliver some photographs. Photographs is, right? Reminds me of the song by Ed Sheeran. We have Ed Sheeran performing also very soon here. Anyway, deliver the some photographs to Mr. M on 15th March 23 against a payment of 10,000. But he dies before that day. Now, here, if it is deliver some photographs, photographs is not personal skill. And since it is not personal skill, in that case, what will happen? In that case, his legal heirs can perform. Will the legal representatives be bound to deliver? Yes, the legal representatives will be bound to deliver, right? A receives certain goods from B, promising to pay 1 lakh. Later, later on, A expressed his inability to make the payment. C, who is known to A, pays 60,000 to B on behalf of A. However, A was not aware of the payment. Now, B is intending to sue A for 1 lakh. Can a third party perform the contract? Yes. And if the promiser accepts the performance of the third party, it is deemed that the if the promisee accepts the performance. Here, C, a third party, has performed on behalf of A and B has accepted it. So, when B has accepted it, third party's performance is equally valid. Can he sue for 1 lakh? No. Can he sue for 40,000? Yes. But can he sue for 1 lakh? No. Nitesh Gupta is constructing his house. If I wear glasses, I'm not comfortable. If I don't wear glasses, my eyes are paining. Guys, you have stopped replying. You have stopped answering. Why? Nitesh Gupta is constructing his house. For this purpose, he entered into a contract with Messrs. Baba Brick House. Oh wow. Some cool name, huh? Messrs. Baba Brick House to supply of 10,000 bricks on 12th August 2023. Messrs. Baba Brick House has two lorries of 5,000 brick capacity. On 12th August, one of the lorries was not in working condition, so they supplied 5,000 brick and promised to supply rest 5,000 on next day. He wanted to cancel the contract as Baba Brick House did not supply been made from its part. Hence, contract should not be cancelled. In this situation, whether Nitesh Gupta can avoid the contract, tell me, what do you think? Can he avoid? Yes, because in part delivery, when I have made a contract that you will deliver me 10,000 and you have only delivered me 5,000, I'm not bound to accept it. So, in case of part delivery, can the promisee reject the goods? Yes, the promisee can reject the goods. So, is he right in rejecting? Yes. So, yes, he can avoid. So, how will you write? What will you write about it? You'll write about what? That performance of the contract means you have to fulfill the whole obligation. When he performs a part of the contract, then in that case, promisee has a right to cancel the contract. A, B, C, and D are four partners in a firm. They jointly promised to pay 6 lakh to F. B and C have become insolvent. B was unable to pay any amount and C could only pay 50,000. A is compelled to pay the whole amount. A is compelled to pay the whole amount to F. Decide the extent to which A can recover the amount from B with reference to the provisions of Indian Contract Act. Okay. So A, B, C, D are four partners in a firm and they jointly promise to pay how much? 6 lakhs. So how much is each of their contribution? How much will be each of their contribution? 1 lakh 25,000. Correct or not? Yes. So each of them will bear 1 lakh 25,000. A and D have their 1 lakh 25,000. B and C have become insolvent. B will not pay any amount. So his 1 lakh 25,000 will be distributed between A and D in their ratio, which is equal, 75,000 each. And now C said, I will pay only how much? 50,000. That means he is paying 50,000. That means how much is left? 35,000. So, iska half of will be borne by each of them. How much is 75,000 ka half? How much is 75,000 ka half? It is 30, 35, correct? 35,500, correct? Am I correct or not? Yeah. 35,500. Guys, have I calculated it correct? So he can recover from him the total of all of this. Is it correct? Correct. 37, sorry. 37,500. That means he can recover this much amount from him. How much does it amount to? 500, 5, 5, 10, 17, 1. I think 2,37,500. Correct or not? Yes, he can recover 2 lakhs. Ayo, what have I done? What calculation did I do wrong? No, my calculation is correct only, no? Here. This calculation is correct. He will pay 50,000. So if he will pay 50,000 out of his 1,25,000, he is paying 50,000. So how much will be left? 25,000 only. Guys, calculate and tell me no total. That Manoj, that is the total. No, you have done it correct. Okay. So how much can he recover? 2,75,000, right? You got it. I mean, this will be the sum total. Please add it up. X, Y, and Z jointly borrowed X, Y, and Z jointly borrowed 50,000, 60 to 500. Where did you get 60 to 500 from, Lavanya? How can it be 60 to 500? See, their own share of 1,25,000 is there. Then B ka share of 1,25,000. It will be what? Divided by 2. This is wrong. That will be what? 2, 6 are 12, 2, 2 are 4. 60 to 500. Correct. 60 to 500. Correct. And plus 1,25,000 may say C will pay 50,000. So how much is left? 75. This is correct, no? 75,000. And 75,000 divided by 2 is 37,500. My God, my maths has gone for a toss. I hope it's clear to all of you. Okay. If you are bad at calculations, please carry your calculator. That will be safer. Now, X, Y, and Z jointly borrowed. Oh my God. Oh my God. I am so sorry. What a blunder. This is 1,50,000. Thank you, Omkar. This is 1,50,000 because 6 lakhs divided by 4 is 1,50,000. Oh, now it is correct. Oh my God, I don't know what have I done. Like this, itna bad calculations so I've never done. Chalo, but please carry your calculators if you are like me. X, Y, and Z jointly borrowed 50,000 from A. The whole amount was repaid to A by Y. Decide in the light of the Indian Contract Act 1872 whether Y can recover the contribution from X and Z. Can Y recover the contribution from X and Z? Yes. Legal representatives of X are liable in case of death of X. Yes, but to the extent of assets inherited. They will not be personally liable. Y can recover the contribution from the assets in case Z becomes insolvent. Yes, he can, but only to the extent it is recoverable, not more. Ajay, Vijay, and Sanjay are partners of a software business and jointly promised to pay 6 lakh to Karthik. Over a period of time, what will be 75,000, Lavanya? Oh my God. Guys, I think there is some problem with my calculation here. Yes, you are correct. This will be 75,000. But please, you understood. No, what a blunder I made in this calculation. I don't know. But you understood the calculation, right? I hope everyone understood the calculation. You guys understood the calculation, correct? Y can recover the contribution from the assets in case Z becomes insolvent. If Z becomes insolvent, can he recover it from the assets of Z? Yes, to the extent it is recoverable, right? Whatever he is able to pay. So, Ajay, Vijay, and Sanjay are partners of a software business and jointly promises to pay 6 lakh to Karthik. Over a period of time, Vijay becomes insolvent, but his assets are sufficient to pay one fourth of his debts. Sanjay is compelled to pay the whole. Decide whether Sanjay is required to pay the whole. Yes, because in case of joint promisors, the promisee can compel any one of the joint promisor to pay the money. Mr. Sonumal, a wealthy individual, provided a loan of 80,000 to Datumal on 26th whatever. The borrower Datumal asked for a further loan of 1,50,000. Sonumal agreed but provided the loan in two parts. On this Mr. Datumal, while paying off part 75,000 to Sonumal, insisted that the lenders should adjust 50,000 towards the loan of this and balance against the loan of this. Sonumal objected to this arrangement and asked the borrower to adjust in order of date of borrowal of funds. First of all, when the debtor is making the payment, can he decide which debt to set off? Yes. And if the creditor accepts the payment, he must set off that debt only. So, can Sonumal refuse or object? No. So, whether contention of Datumal is correct or otherwise, yes, it is correct. What would be your answer in case the borrower does not insist on such order of adjustment? If he does not insist, then the creditor may set off any debt. What would be the mode of adjustment in case neither both the parties are making any adjustment? Then in that case, first in, first out. The debt first in order of time will be set off first. Correct? Mr. Murari owes payment of three bills to Mr. Giridhar. 12120, which is due on May 2016, 56509680. He made a payment as below without any notice. A check of 9680. When the debtor makes the specification, we have to set off that debt only. Here, he did not say anything, but this loan amount is an exact replica of the loan amount. It's an implied what? Specification that please set off this debt. From the balance 15,000, he can set off, right? First, he can set off this debt because it is time barred, and the balance he can set off from this debt. He owes G the following debts as per the table given below. 5,000, which is time barred on this day, 3,000 time barred on this day, 12,500, 10,000, 7,500. On this, he makes a payment without any notice. A check of 12,500. Now, since it's an exact replica, it is please pay off this amount. A check of 4,000, nothing is given. So it will be debt in first order of time. And you know what? When we say order of time, even a time bar debt can be set off in this case. So this 4,000 will be set off against this because it's on the same day. They are becoming time barred on the same day. That means they are payable on the same day. Since nothing is given, since the amount is not enough to set off both, right? 4,000 and here it is 8,000. And nothing is specified for this. It will be set off in their proportion. Yes, yes. Sheena was a classical dancer. She entered into an agreement with Sheetal Vidya Mandir for 60 dance performances. As per the contract, she was supposed to perform every weekend and she'll be paid 10,000 per performance. However, after a month, she was absent without informing due to personal reasons. Yes, correct, correct. 5:3 ka ratio, correct. Answer the following questions. She was absent. First of all, she entered for dance performance. Can I say time is of essence? Because it's a live show. Yeah, time is of essence, right? Time is of essence. So whether management of Sheetal Vidya Mandir has a right to terminate? Yes, because when time is of essence, the contract is voidable. And when the aggrieved party fails to perform, the contract is voidable. Yes. If the management of Sheetal Vidya Mandir informed Sheena about its continuation, can the management still rescind the contract? No. Why? Because a voidable contract once ratified cannot be cancelled. Right? A voidable contract once ratified cannot be cancelled. Can Sheetal Vidya Mandir claim damages that it has suffered because of this breach? In case they cancel the contract, the damages can be claimed. In case they accept the contract, damages can be claimed only if it is mentioned. Mr. Nikhil has decided to get interior work for his new office. For this purpose, he entered into a contract with Messrs. Sherry Fine Interiors. It was agreed that Sherry Fine Interiors will complete the work latest by 31st Jan. On 31st Jan 23, Mr. Nikhil observed that only 20 to 30% work has been completed. He decided to cancel. When we have mentioned the time and it has to be done within that time, time is of essence, correct or not? He decided to cancel the contract. On cancellation, Messrs. Sherry Fine Interiors filed a suit against Nikhil for recovery of the cost which it has incurred on the interior work. Mr. Nikhil argued that Messrs. Sherry Fine Interiors did not complete the work within the time as per the contract, and further, the work done till 31st was of no use for him as he has to appoint a new interior. Explain whether Mr. Nikhil is liable to pay the cost. So, is he liable to pay the cost of the work? Here, time was of essence. He can cancel the contract. If he cancels the contract, is he liable? No. He said it was of no use and he will have to hire a new interior. So, in case of time, yeah, time of essence, you can cancel the contract and he will not be liable to pay anything because I repeat again, the work was never of no use to him. So he's not liable to pay. If the work was of use to him, is he liable to pay? Yes. Mr. X was a disc jockey at a five-star hotel bar. As per the contract, he is supposed to perform every weekend. He's supposed to perform, he's a DJ, perform every weekend. Time is of essence. Correct or not? Time is of essence. Mr. X will be paid 1500 per day. However, after a month, he willfully absents himself. Does the hotel have a right to end the contract? Yes, the contract is voidable because time is of essence and he willfully absents himself. If the hotel sends out a mail to X that they are interested to continue, once they have accepted it's a valid contract, can the hotel rescind the contract after a month? No. Why voidable contract once accepted cannot be cancelled, once ratified cannot be cancelled? Same question we have done. In which of the cases can the hotel claim the damages? Termination of contract, yes. Continuation of contract, only if it is mentioned, then can claim the damage. Mr. Singhania entered into a contract with Mr. Sonu to sing in his hotel for 6 weeks on every Saturday and Sunday. Time is of essence? Yes. And promised to pay 20,000 for every performance. Mr. Sonu performed for 2 weeks, but on the third week, his health condition was very bad, so he did not come to sing. Mr. Singhania terminated the contract. Can he terminate the contract? Yes, because contract is voidable because time is of essence. What would be your answer in case Mr. Sonu turns up in the fourth week and Mr. Singhania allows him to perform without saying anything? That means he has accepted the contract. Contract was voidable, he has accepted it. What would be your answer in case Sonu sends Mika on his place in the third week and Mr. Singhania allows? First of all, it's based on personal skill. So third party cannot perform. But when he sends Mika to perform and he accepts it, he has accepted the contract. Now the contract is absolutely valid. Why? Because the contract is ratified. Woolen Garments Limited entered into a contract with a group of women in July 23 to supply various woolen clothes for men, women, and kids like sweaters, monkey caps, mufflers, etc. Before the commencement of the winter season, that means, can I say time is of essence here? Yes. The agreement expressly provides that the woolen clothes shall be supplied by the end of October before the starting of winter season. However, due to prolonged strike, women group could tender. Acha, by the way, strike, is it supervening impossibility? No. Could tender the supplies in March 24 when the winter season was almost over. Time is of essence. Can the company reject the total supply? Yes. Time is of essence. And when in a contract, time is of essence, the contract is what? Voidable. Whether company can accept the total supply. Yes, the contract is voidable. So if the company wants, they can accept the total supply. Examine the validity of the following. Examine the validity of the following contracts as per the Indian Contract Act, giving reasons. J contracts to take a cargo for K at a foreign port. J's government declares war against the country in which the port is situated, and therefore the contract could not be fulfilled. K wants to file a suit against J. No. Why? Subsequent impossibility. Answers are not coming, guys. Subsequent impossibility. And since it's subsequent impossibility, the contract is what? The contract is void. And can you sue? No. Mr. Jhoot, Mr. Jhoot entered into an agreement with Mr. Such to purchase his motor car for 5 lakh within a period of 3 months. Security amount is never an advance money, remember, huh? Of 20,000 was also paid to Jhoot to Mr. Such in terms of agreement. After completion of 3 months of entering into the agreement, Mr. Such tried to contact Jhoot to purchase the car. Even after lapse of another 6 months period, Jhoot neither responded to Such nor to his phone calls. After lapse of another period of 6 months, Jhoot contracted Such and denied to purchase the car. He also demanded back the security amount. This security amount is not an advance money. It is a caution money which is given for performance of the contract. And here, will restitution apply? No. So please remember, the person is not liable to refund the security money. And here, the Jhoot did not respond till 1 year. It's his fault. So can he demand back the money? State whether Such is required to refund the money. No. But what would be the validity of the claim made by Jhoot if the motor car is destroyed by an accident within 3 months agreement? If the motor car is destroyed by an agreement, then in that case it is subsequent impossibility, correct? It is what? Subsequent impossibility. And in case of subsequent impossibility, are you liable to refund the money? Yes, you are liable to refund the money. Correct? Can we go forward to the next? I hope answers you're having your answers. Everyone should be answering. Very important. Mr. J entered into an agreement with Mr. S to purchase his house for 20 lakh within 3 months. He also paid 50,000 as token money. In the meanwhile, in an anti-encroachment drive of the local administration, Mr. S's house was demolished. Okay, this was anti-encroachment drive of the local administration. This is what? Government. Can we say this is subsequent impossibility? Correct or not? Yes. Mr. S's house was demolished. When Mr. J was informed about the incident, he asked for the refund of the token money. Can he ask for the refund of the token money? Yes. Yes. Why? Because he never got the house. So, referring to the relevant provisions, state whether J is entitled to the refund. Yes, it's a subsequent impossibility. And in subsequent impossibility, can I ask for the refund of the money? Yes, yes, refund should be given. Correct, guys. Mr. Rich aspired to get a self portrait made by an artist. He went to the workshop of C, an artist, and asked whether he could sketch the former's portrait on oil painting canvas. Mr. C agreed to the offer and asked for 50,000 as full advance payment for the above creative work. Mr. C agreed to the offer and asked Mr. C clarified that the painting shall be completed in 10 sittings and shall take 3 months. On reaching the workshop for the sixth sitting, Rich was informed that C has become paralyzed and would not be able to paint in the near future. C had a son who was still pursuing his studies and not taken up his father's profession yet. Can Rich ask K to complete the work in lieu of his father? No. Why? Because it is based on personal skill. And if it is based on personal skill, only the promiser must perform. Could Mr. Rich ask Mr. K for the refund of money paid in advance? Yes. In case of subsequent impossibility, if I have paid any money, I have a right to get the refund. So here we have two provisions: subsequent impossibility and restitution. Please, when you are writing, make sure you write it in specific order, particular correct order. State which of the following agreements are valid under the Indian Contract Act 1872. A, who owns two cars, is selling red car to B. B thinks he is purchasing the black car. Void. Consensus ad. There is no consensus ad idem. Also, there is bilateral mistake of fact. A threatened to shoot B. Yeah. If B does not lend him 2 lakh and B agreed to it. Voidable. Why? Coercion. A agrees to sell his house to B against 100 kgs of cocaine. Illegal. Void. Why? Because consideration is illegal. A asks B if he wants to buy his bike for 50,000. B agrees to buy the bike. Valid. I'm offering, you are buying. X agrees to write a book with a publisher, but after a few days, X dies in an accident. Void. Why? Subsequent impossibility. Whether the following agreements are valid or void. Vijay agrees with Saini to sell his black horse for 3 lakh. Unknown to both the parties, the horse was dead. Void. Initial impossibility. Bilateral mistake of fact. Sarvesh sells the goodwill of his shop to Vikash for 10 lakh and promises not to carry on such business forever and anywhere in India. Void. Forever and anywhere in India. Unreasonable terms. Void. X agrees to after. Okay, the same thing we already discussed. Void. Why? Subsequent impossibility. Correct, correct, correct. Point out with reasons whether the following are valid or void. Kamla promises Ramesh to lend 5 lakh in lieu of consideration that Ramesh gets Kamla's marriage dissolved and he himself marries her. Void. Why? Immoral agreement. Sohan agrees with Mohan to sell his black horse. Unknown to both the parties, the horse was dead at the time of agreement. Void. Why? Bilateral mistake of fact and initial impossibility or impossibility existing at the time of contract. Ram sells the goodwill of his shop and promises not to carry the business. Okay, same we have already done. Anywhere in India, unreasonable. In an agreement between Prakash and Girish, there is a condition that they will not institute legal proceedings against each other without consent. Okay, this is valid or void? It's void. Why? Because every person has a right to go to the court. I don't need your approval to go to the court. Ramamurthy, who is a citizen of India, enters into an agreement with an alien friend. I can make a contract with an alien friend. It's absolutely valid. Mr. S, whether the following answer the following. Mr. S and Mr. R made a contract wherein S agreed to deliver paper cup manufacturing machine to R and to receive payment on delivery. On the delivery date, R didn't pay the agreed price. Decide whether S is bound to fulfill his promise at the time of delivery. No. In case of reciprocal promises, if one party prevents the other from performing, the party prevented has no obligation to perform, right? That is, if one of the parties does not perform, the other need not perform. Where? Where did I write? I wrote valid. That's valid. I wrote valid. My handwriting, that's a different story. Even I cannot identify my handwriting after some days. Not after some days, after few minutes or few hours. Okay. Mr. Y gives a loan to Mr. G. So here basically one will perform and the other will perform. We have to perform it simultaneously and one has not performed. So when one has not performed, the other is not bound to perform. Mr. Y gives a loan to G. Mr. G defaulted the loan on the due date and now the debt has become time barred. After the time barred debt, Mr. G agreed to settle the full amount to Mr. Y, whether acceptance is enforceable by law or not. It is enforceable by law if it is in writing. If it is a written promise to pay a time barred debt, then it is a valid enforceable contract, otherwise not. A and B entered into a contract to supply unique item, alternate of which is not available in the market. A refused to supply the agreed item. What directions could be given by the court for breach of such contract? Can the court ask him to actually perform the contract? Yes or no? This is what? Specific performance, right? Court can actually order him to perform the contract for specific performance. Mr. X promised to bring back Mr. Y to life again. Wow. Wish. A agreed to sell 50 kgs of apple to B. The loaded truck left for delivery on 15th March, but due to riots in between, reached B on 19th March. Okay, here time is of essence, and I have not performed within time. So the contract becomes what? Void, double. Riots is not supervening impossibility, so no remedies. An artist promised to paint on the fixed date for a fixed amount of remuneration but met with an accident and lost his hands. It is what? Void. Why is it void? Why is it void? Why is it void? Hello. Why is it void, guys? Because it is subsequent impossibility. Abhishek entered into a contract of import of toys from China, but due to disturbance in the relation of both the parties, the import from China was banned. Again, it is what? Void. Why is it void? Why is it void? Because outbreak of war. I mean, because of this, it's a government thing. So it has now become unlawful to do it. So it's void. It is basically subsequent impossibility. Dia promises Summer to lend 5 lakh in lieu of consideration that Summer. This we have already done. I'm not discussing. This we have already done. Not going into it. This we have already done. The horse is dead. We have already done. Marriage dissolved and he himself marries her. Done. Business forever and anywhere in India already done. This is also already done. Okay, not going into this question. We've already done this. Okay, this also is already done. This is also done. So I'm not going into those two questions because we've already done it. Can I move to the next unit? This is the last unit of discussion because as special contracts is already done. If you want, please check the video of the special contracts. This is already done. And you can find the videos of all the other Swift scans in the link given below. You can check in the description box, the links are given. And in those links, you'll find all of it. Okay. What? Okay. Question number, unit 6 ka first question. Mr. X and Mr. Y entered into a contract by which X had to supply 50 tons of sugar to Y at a certain price strictly within a period of 10 days. Mr. Y also paid an amount of 50,000 towards advance as per it's strictly within a period of 10 days. Towards advance as per the terms of the above contract. The mode of transportation available between their places is roadway only. Severe flood came on 2nd August and the only road connecting their place was damaged and could not be repaired. Within 15 days, Mr. X offered to supply sugar on 20th August, for which Y did not agree. On 1st September, X claimed compensation of 10,000. Okay. First of all, time is off. I mean, he specifically mentioned I wanted it in this time. It happened that the roads were blocked, which was supervening impossibility. Can I call it supervening impossibility? Yes, it is supervening impossibility. Now, X offered to supply sugar on 20th August, for which Y did not agree. Can he refuse? Can he refuse? Yes, I wanted it within the time. I did not get it within the time. Can I refuse? Yes. On 1st September, X claimed compensation of 10,000 from Y for refusing to accept the supply of the goods. X is saying you did not accept the goods on 20th. Give me damages. Can he say that? No. Time was of essence. I mentioned the time. You could not supply. You cannot claim damages. No. On the other hand, Y claimed refund of 50,000, which he has paid as advance. Can he claim the refund of 50,000? Yes. In case of subsequent impossibility, can you ask for the refund of the money paid? Yes. I hope it is clear. So X will not get compensation and he will have to refund the advance. PM Limited contracts with Gupta traders to make and deliver certain machinery to them by 30th June 2017 for 2150 lakhs. Due to labor strike, labor strike, is it supervening impossibility? No. PM Limited could not manufacture and deliver the machinery to Gupta traders. Later, Gupta traders procured the machinery from another manufacturer for 2275. Can they claim? And Gupta traders was also prevented from performing a contract which it had made with Zenith traders at the time of contract with PM. What is the amount of damage? First of all, He was supposed to supply at 2150, but he couldn't supply, so he had to buy at 2275. Can you claim this ordinary damage? Yes. An ordinary damage is generally calculated as a difference between market price and contract price. So can you claim this damage? Yes. It is what? 1.25 lakh. Yes. Can you claim the damage that he suffered for not supplying the goods to Zenith traders? Can he also claim the damages that he has suffered due to non delivery of goods to Zenith traders? No. Why not? Because special damages can be claimed only when notice of special loss is given, right? On 1st March, P Ready-Made Dress Garments Shimla enters into a contract with J Ready-Made Garments Jaipur for supply of different sizes of, correct guys, correct, different sizes of shirts. As per the terms of the contract, 300 pieces of each category, right, was to be supplied at, small was to be supplied at 900, medium at 1000, large at 1100. And each of them was going to be 300 pieces of each category. However, on 1st May, they informed that the firm is not willing to supply the shirts as the rate due to the rise of the prices in the raw material cost. And now they are saying for small you have to pay us 1000, for this medium 1100, for this 1200. Once you have fixed the price in the contract, can you later ask for a different price? No. Can I claim ordinary damages in that case? Yes. What is the ordinary damage? 100 for each of the size into 300, which is equal to how much? So can they claim 90,000 as damages? Yes. So you will write about what? First, you will write about what? Breach of contract. And second, you will write about damages here. Mr. Maruti was traveling with his wife by bus of Himalaya Travels Private Limited. Due to some technical default in the bus, the driver had to stop the bus in midway in cold night. Driver advised the passengers to get the shelter in the nearest hotel, which was at a distance of only 1 kilometer from that place. The wife of Mr. Murthy caught cold and fell ill due to being asked to get down, and she had to walk in cold night to reach the hotel. Mr. Murthy filed the suit against Himalaya Travels Private Limited for damages for personal inconvenience. Will he get that? Yes, ordinary damage. Hotel charges. Yes, special damage because I had to take the hotel room because your bus was not working. Medical treatment. No, because this is considered as a remote damage. What is the damage you suffered? You suffered personal inconvenience that I'm already giving you, and you had to pay the hotel charges. That nothing else can be claimed. Seema was running a boutique in New Delhi. She had to deliver some cloth to her friend Kiran, who was putting up an exhibition at Mumbai. Seema delivered the sewing machine and some cloth to a railway company to be delivered at a place where the exhibition was to be held. Seema expected to earn an exceptional profit. However, she did not bring this fact to the notice of the railway authorities. The goods were delivered on the conclusion of the exhibition. Can she claim the loss of profit? Can she claim the loss of profit? No. Why? Because she never informed the railway company about the special case. If she would have mentioned, could she have claimed the loss of profit? Yes. But here, because it was not mentioned, she cannot claim. X entered into a contract with Y to supply him water bottles at rupees 5. And for this, he made a contract with Z to purchase water bottles at 4.50. Z did not supply the bottles and the price went to 5.25. Can he claim the damages? Yes. What is the damage? Market price less contract price, which is 1.25, no, 0.75, sorry, which is 0.75 per bottle. So calculate the amount of damage that X could claim from Z. What would be your answer if Z had not informed about Y's contract? If Z had not informed about Y's contract, this is my damage. But if he would have told Z that I am going to sell the bottle to Y at rupees 5, then in that case, I was going to sell you at 4.5, you were going to sell at 5. Your maximum damage is what? 0.50. Then what damages can he claim? He can only claim 50 paise per bottle. Oh, wow, with this we are done. Okay, guys. So with this, we are done with the questions of Indian Contract Act. Special contract, I already told you. You will find it in the video, and the link is given in the description box below. You can check it there. With this, we are done with Indian Contract Act, and you have to quickly tell me you want me to do Sale of Goods Act. If you want me to do Sale of Goods Act, you have to immediately drop a message here so that I can arrange a link for 345 for Sale of Goods Act. Please immediately drop a message here so that if you want me to do it, I can immediately make a link of, the class at 3:45. Okay, you want me to do it? Chalo, theek hai, I'll arrange it. Okay, I'll do it. Just give me 15-20 minutes. My throat is like completely choked. I need to just rest for 15 minutes and then I'll send the link in my group. Okay? Chalo, I'll see you all in 15-20 minutes. Be back, go and eat something.